on the side. And if I have one player show up for practice, well, then it's a friggin' private training session. Good for you for showing up. The real tragedy would be if I left, you know, after driving almost an hour and 15 minutes from Normandy Park because of the crazy traffic, you know, not to serve any purpose.
Yeah.
But can I just, I'll just use this chair, I guess?
I was wondering, yeah.
Yeah, let's just do this. So, I just feel really like formal.
What they think is the most important issues most people in society are preventing.
All right, Caitlin, thanks for joining us. Traffic was a nightmare tonight.
Horrifying.
Caitlin is with an associate attorney at Dimensions Law Group. Dimensions Law Group focuses on business law, commercial and residential real estate, landlord-tenant matters, and estate planning. Caitlin currently serves on the board of several nonprofits. How many?
Two right now.
nonprofits.
I just no longer. I was 3, and now it's like that's too much. That's a
Well,
lot. That's a lot.
Including the executive board of Highline School Foundation. In addition, Caitlin is heavily involved in leadership roles with Highline Soccer Association. Caitlin received her Juris Doctorate from Seattle University School of Law and 2 bachelor's degrees from Seattle U. Prior to attending law school, Caitlin gained important legal experience as a paralegal at several large and mid-sized law firms. Caitlin is passionate about helping people, families, and businesses navigate estate planning, business, and the ever-changing commercial and residential real estate markets. She is a member of the Washington State Bar Association. Is there anything I left out there?
Yeah, so I probably haven't updated things, but I'm also a member of the Rental Housing Association of Washington and will actually be on the board of that organization beginning January of 2022.
Awesome. Well, the reason we put this together is we wanted to, number one, get people out. Not many people join us in person tonight, but we have a few people on Zoom. We want to invite key professionals. Caitlin, being in real estate law, can help point us in the right direction with things. And I wanted to involve our team in the purpose of strengthening our community, strengthening our team, and broadening our horizons in information. Yeah, so I guess I'll turn the time over to Caitlin and see where this takes us.
Thanks for having me out. Yep, it was crazy getting here. I'm just gonna chalk that up to maybe why we didn't have very many people show up, because they just looked at the red line on their Google map and just went, not tonight. I looked at it too. Okay, so what I was gonna go over tonight was some of the current statuses, I guess, if that's accurate, of the eviction moratoriums in the state of Washington, or at least hurdles, if we won't call them moratoriums, to consider. Also, recent landlord-tenant law changes that went into effect in 2021. And also looking at sort of local ordinances that are either actively changing or will likely change in the immediate future. I will focus my time on, sort of south of Seattle, and not Seattle tonight unless specifically asked. So first things first, when we're talking about residential real property in the state of Washington that is used as a rental, the first question that I almost get every day if I'm dealing with a client that's a landlord or a property owner or a property management company owner, whatever that may be, is, how do we collect rent if a tenant cannot pay? What does the process look like right now? And what that process looks like right now is an absolute horror story. So buckle up. The current proclamation that governs your options and next steps is Proclamation 20-19.2. And you need to combine that proclamation and its terms with any additional local ordinances that have been passed because they can stack requirements on top of whatever the state rules, laws, and proclamations are. The additional thing that you need to look at once the current proclamation has expired is RCW 59-18-630, which lays out the landlord mitigation process that is a requirement now if you are going to pursue a tenant for non-payment of rent and potentially evict them for failure to pay. And that is going to be in place for the foreseeable future. It is currently called a pilot. I won't say I guarantee, but I will say it's highly likely that it is not a pilot, that they called it a pilot so that it will become permanent in the RCW forever. So general outline, 21-09.1 and 09.2 came into existence after the, we'll call them COVID eviction moratoriums that the governor's office had put into place starting in March of 2020. What happened there was we had, those proclamations were 20-19.0123456. That's how many times it was extended, and different iterations of that proclamation. Come May of 2021, so this year, April and May, the legislature passed the 5160 and 1236 bills. One of those actually told the governor in writing in the bill and in the law, the governor's office shall not extend the eviction moratorium 20-19.6 beyond June 30th of 2021. The governor's office essentially laughed at that and said, okay, I will not extend 20-19.6. I'll create a new moratorium with a new numbering system, and I will call it a bridge. So that was a cute attempt by the legislature to exert some legislative power. Not to make this political, that's actually just what happened. So 21-19, or sorry, 09, where we're at now in 0.1 and 0.2, I'm sorry, 21-09 and 19, I'm sorry, so I have a typo here. Essentially says that if you are a landlord that is owed money for rent, before you can do anything or file anything or send any notice to the tenant requiring the tenant to vacate or requiring the tenant to pay, you first have to ensure that the county that the property is located in has an eviction resolution program up and running or quote unquote operational. So the rental assistance program is operational. They defined that term as it's located in the county where the rental property is located. It's receiving or able to receive applications for rental assistance from eligible renters and landlords, is currently dispersing or is able to disperse funds, and remains open throughout the time of the order. So that's one of the things that has to be true in the county where the property is located in. If you have a property in Tacoma, you'd say, hey, does Pierce County have an operational ERPB or eviction resolution pilot program? And we have to make sure that you can check that box before you could send anything to the tenant that had any words about, requirement to pay. The issue here and the hurdle to deal with is that there's a lot of pieces of this definition of operational, because it says it has to currently dispersing or able to disperse funds. How would you know that? Yeah. and it doesn't restrict those programs from being operational one day and then not being operational the next day. And that is actually happening in some of these counties where they're opening up that sort of online application process, and then you might log in the next day and they're not accepting applications anymore. And then, or you get through that application process and they no longer have any more funds, and so they're no longer able to disperse those funds. So it can be a process of like stop, go, stop, go, stop, go, which that's what I think many people are experiencing. The second piece to this is that the operational eviction resolution pilot program, it has to serve It's able to serve pilot program clients and is located in a jurisdiction which a standing judicial order of the Superior Court exists. So you have to have operational, and there has to be a standing order issued by the local Superior Court that lays out what their process is. So you've got to go step 1, step 2. Thankfully, most counties in the state of Washington have judges and chief judges who've finally created their standing orders. And thankfully, those standing orders, once they are posted, they are not removed later. So usually hurdle number 1 is the biggest issue. The problem with the standing orders is it doesn't really have any sort of limitations about what can be in those orders. So if you're a landlord-tenant attorney like I am, or I would say a landlord attorney, I have to, before I serve anything and before I advise my client, look at what the local standing order says. And actually every piece of advice I give has to be with the context of what is this county's standing order say? What is this county's? Essentially what the governor's office has done, there are 39 counties in the state of Washington, is create 39 different legal processes for processing a non-payment of rent case in the state of Washington. And what I find interesting about that is that this was supposed to make things simple. The other piece another piece that has to be true is the proclamation directs each county grantee. So any entity within that county that is receiving funds, right, from the government to disperse for, mitigation, let tenant, to reinstate tenancies, pay rent, whatever that may be. They have to attest when their rental assistance programs, just the funding programs, are also operational. So the problem with that is there's no requirement. They can say, yeah, we're operational one day, we're not operational another day. And there's no timeline for them to do that. I mean, essentially there's no teeth to this to get the funding programs to attest that they have the funding and start dispersing it. Or for the ERPP programs, so eviction resolution pilot programs, to have like a drop dead date of like, this is when you need to be operational. This is the law now. You have to function. You need to let landlords force a tenant who's not paying and not communicating and not participating in any way to this money. Because at this point, most funding from the government, whether it's state government or federal funding, only it requires tenant cooperation to apply for. So a landlord can't just, and in most cases, and I know that there are exceptions to this, but in most cases, a landlord can't simply say, my tenant's not paying me, this is what they owe me, please pay me.
Right.
It takes some cooperation. So the tenants that are really doing the most harm in the landlord world are actually the ones that they're being rewarded by their lack of communication, right? Okay, so imagine for a minute that you are in one of the rare counties that exists in our state where the standing order has been posted. The ERPP program has, basically said that they are operational, that they are receiving applications. So let's say all those boxes are checked. I don't think there's very many counties that you can say that about right now. I think it's Snohomish and possibly Pierce. But there are other issues that you're gonna have to deal with, at least on the west side. I can't speak to the east side of the mountains. But let's say you do that. What the process looks like from there moving forward is the first thing that the landlord has to do is send the tenant an offer of a reasonable repayment plan. And that reasonable repayment plan is defined by the new laws passed by the legislature as, you take your balance owed and you say, you owe me, let's hypothetically say $10,000 and rent is $1,500 a month. You can only require them to pay 1/3 of 1 month's rent, every 30 days or whatever. No interest, no late fees, no requirement that, hey, if you accept this payment plan, you need to stay current on your rent, you need to, comply with your lease terms. Basically, it just has to be, that's basically it, is you can pay 1/3 of your month's rent every 30 days, no interest, late fees, until this is paid in full. That's the outline. They have to have 14 days to respond to that offer. If they do not respond, then what the landlord must do is send a notice. It's called an eviction resolution pilot program notice number 1 in resources. So it's send the notice of hey, you haven't responded to me. Here's the notice that I want to participate in this eviction resolution pilot program and the resources that are available to you. And essentially, they have 14 days to respond to that notice. And if they don't respond, then hypothetically, looking at your local standing order, what most counties are saying is then you contact the eviction resolution pilot program lead or whoever's communicating, and you show that you sent your 14-day notice to of offer of reasonable repayment plan. You show you sent the 14-day notice, ERPP notice and resources. You show, timelines have been met, and you ask for a certification, basically a certificate from the ERPP program saying, I have done everything under the law that I'm required to do. And you can take that certification and attach it to your lawsuit, which would become a summons and complaint for unlawful detainer, and then you can go to court, and then you start the court process. So all of this has to be done before you can even knock on the court's door or serve any sort of notice. And I'm sorry, I should back up a step there. Depending on the county that you're in, when you send your notice of ERPP and resources, you can also send the 14-day notice to pay rent or vacate. But depending on the local standing order, some standing orders are actually requiring you to separate those notices as well and put 14 days between those notices as well. So now we're looking at like 45 days in some counties before you can knock on the court's door. And I hate to scare people, but I'm sorry, but this is really where it's going. So that was if the tenant, does no response, right? No participation. You can go to court, but then you have to serve your lawsuit on the defendant and give them an opportunity to respond to that lawsuit. And what can happen is maybe they respond, and they don't need to respond with anything substantive. They could just say a notice of appearance, for example. And you could, issue a court hearing and show up, and they could say, oh, I've been affected by COVID. I didn't know what my rights were. And the court could actually order you to go back to mediation and say, okay, well, I want you to go to mediation. So now you got to backtrack to mediation. And there's no timeline right now for how long mediation can take. So you could get stuck in the mediation loop for an unknown period of time. An example of this is that I have heard from good resources in King County, even though King County's operation program is not operational, they are operational. They're just not saying they're operational. Is that they will offer one Zoom mediation a week. There's like one day that you can do it. So it could take, and there's only so many appointments. So imagine how many people are in King County and how many of these cases are going on. That could drag on. I have no idea how long it could possibly drag on, but probably a long time. So looking forward to, if you go to court, they could order you back to mediation, or they could order the case forward. And if they order the case forward, you're just going through your process of proving you followed all the rules, this person didn't pay. And they actually have, because of the new laws, I think it was under 5160, which is now codified into the landlord tenant law, that they all have a right, indigent tenants have a right to counsel. So we basically now have a whole public defender arm of taxpayer funded attorneys that are just for indigent tenants in eviction cases like this, which I find interesting because I don't think there's any other replication of this in our jurisprudence of basically the homeowner or the property owner is paying for their attorney, their own attorney, the court system that they are using, and the defendant's attorney's fees. That's essentially, I was thinking about that earlier, and I was like, wait, so what about like criminal cases? And I was thinking, well, actually, if you're the plaintiff, you're the state, like you aren't paying this directly, an attorney fee for the prosecutor's office to prosecute the case if you're a victim of crime, right? So this is really the only example I could possibly think of where it's just like, you're just paying, you're Britney Spears.
Yeah.
You're just paying everybody's fees, right? So, and I'm sorry if that's like, a little ho-hum, but that is kind of the way I think about it for now. Okay, so that's what the status of evictions are or the eviction process for non-payment of rent in the state of Washington under the current proclamation. Now remember, these proclamations are temporary. Let's put, quotation marks around that. The current one is set to expire October 31st. When I was driving here tonight, there was a little blip on NPR that was like, studies show that, if you allow evictions during a pandemic, that it spreads the virus. And it was not really like supportive, but it just felt kind of political and how it was timed and placed. And I was thinking to myself, this is just a predicate for us to hear again from our governor that they're going to extend the eviction moratorium. We're going to get a 21-19.3. And as many people may know, Seattle recently, their mayor, Jenny Durkin, just announced that they are extending their moratorium through January 15th of 2022. Burien just announced that they're matching that. I think it's Kirkland that also just announced that they're matching that. So I really feel like it's only a matter of time before our governor also matches that. I hope not, but that's my opinion of what's likely, especially since there's a couple things that I hope people are generally aware of, which is the federal funds that are given to our state to disperse for tenants to, help them during this time, they expire. Some of them expired in like at the end of September. So because you can't force tenants to access these funds and to apply for them and to get them directly, you're basically just letting that money flow out the door back to the federal government, even though there are real people in our state that need it, but the tenant is holding it hostage. And so the longer that these eviction moratoriums go, basically hold that back or allow this to happen, the more money we actually waste and we will see not utilized. The other problem with it is many of the eviction resolution funding programs that our state has. So the eviction, I think it's called landlord mitigation program. It's run through the Washington State Department of Commerce. Limits these funds that tenants can get access to $15,000, which in the beginning of the pandemic sounded like a lot of money. When they announced these things back in July and August of 2020, people were like, oh, okay, so we can get up to $15,000 if the tenant falls that far behind. That's fine. Problem is once again, tenants aren't forced to do it. They don't have to, participate. And now if you had rent that was, let's say hypothetically $2,000 a month, which I would say is pretty average in many areas. And that started in March of 2020. You are owed at this point, can somebody do the arithmetic? But we're talking 30, 35, 36, $36,000 that you're owed at this point. So that $15,000 is less than half of what you're owed. And as part of accepting those funds, you are required to waive going after the tenant for any additional amounts. So the government is capping what you're allowed to collect, either from the government or from the tenant. Great. Yeah, I bet you were hoping for good news tonight.
No.
Yeah.
We had a hearing yesterday.
Who's we?
Our firm had a hearing, an eviction hearing,
Oh, you had a show cause hearing.
show cause hearing. And I don't think it was, the city had asked us to evict him,
Code violations.
code violations, and we also threw on there, unpaid rent. Right, so, he no-showed, so he had, till the end of yesterday to respond, so we're still waiting to see on that. My question to you is, have you seen any successes with the RPP? Has anybody successfully gone through and got a certificate?
Which county?
Any?
Oh, yeah. I think, I want to say I've heard rumors with other attorneys
Of
that,
course.
that Snohomish County issued a couple certificates. Wow. But that is the problem with being an attorney in this field is you're really only involved in worst case scenarios. So if something works, then oftentimes I don't hear about it. It's only when it doesn't work that my phone number is called. So, but I do have access to really good listservs and other attorneys that have kind of in the landlord tenant world gathered together to be like, we have to survive this together. So essentially because with we've probably dealt with 100 law changes in the last almost 2 years at this point. And it has been a absolute roller coaster trying to actually be able to provide competent advice and stay on top of these things. And these laws are drafted in a very rushed manner without a whole lot of debate, if any at all. So many of them create more questions than they do answers. So it's been working double duty for landlord attorneys trying to keep up. Many attorneys actually got out. They don't even do it anymore. Really? Because they're like, they couldn't keep up. Yeah, I can definitely say that very, very confidently. Wow. As a matter of fact, I've received many phone calls of like, I'm not doing these anymore. Can you just handle these cases? I have access to those things, and the reports are grim about getting that certificate.
We've applied for a handful and have not received one yet.
Right, they have no timeline that they have to meet that with, and there are politics in this, meaning like their job is to keep, and their focus is keeping people housed, right? If they issue that certificate, they know that that person, whether deservedly or not, it could become unhoused. If they don't have any political motivation to, have to move forward according to the law, they will consider it a success that every day that they withhold landlords access to the law or to the court system. Yes, and frankly, I've had conversations with people that are in, other side, in the actual, government side of this, and that's exactly right. It's especially like think about King County not being operational. King County is the most populous county, I think, in the state. They have the most money. They've actually had a resolution pilot program up long before any of the other programs existed in most other counties. Yet there are small counties that are operational that have very little funding, but King County is somehow not operational. It's not because they don't have the funding. It's not because they don't have the system. They just don't have any political reason to move forward. Yeah. Tenants outnumber in votes owners. So they're just going to be like, who should I please? That's true. Yeah. that's it. And I'm not somebody that's like a heartless individual that just wants to evict all these people at all. I mean, I completely, from a human standpoint, understand the harm of evictions and, try to do it as sparingly as possible. Sure. But at the end of the day, if you are residing in a property and you don't have the funds to keep up with it and you're not, holding up your end of the bargain, there has to be some sort of end date to that. There has to be a staunching of the bleeding. So that's not fair. Okay.
Okay.
Yeah.
Can I tangent you again? Sorry.
Sure, you can do whatever you want.
Our
just us.
We've got a few folks on Zoom that are here with us. So 5 to be exact.
Oh,
so,
exciting.
So we're part of a franchise, nationwide franchise. And so I've got a lot of friends across the nation: Texas, Utah, California, Washington, D.C., Maryland, Florida. They have different rules and regulations in every state, right? Nobody's going through what we're going through.
Washington's the worst.
Why is there any landscape for why that is?
I don't think I can answer that question without just going into straight up
You are being
political dialogue.
recorded, by the way.
Yeah, political dialogue. I mean,
Okay.
it's because of our politics.
Yeah,
Yeah, it's 100% politics.
all starts at the top.
It looks really good when you get to say in our state that I prevented evictions, no matter what the cost is on the other side, right? The political focus is simply no evictions at all cost. That's it. That's really,
What gain is that?
I mean, you'd have to ask the people, right?
What
You'd have to
status
have a conversation with those people making the decisions. I think that I consider myself a pretty rational human being, so I like to look at things from both perspectives and find a middle ground. But you can look at nationwide politics right now, and that's not a winning strategy if you want to stay in your position. Your position has to be super extreme in order for you to stay in your position. So then the result of that is that laws and bills have to be equally extreme.
polarizing?
Exactly. Yeah, that's really what's going on here. Rational thought or middle ground approaches are, not sexy politics.
Okay.
Yeah.
Thank you.
Problem. I mean, that's just personal opinion, though. It's not anything other than that. Okay, so there are other pieces of the current proclamation that are relevant for things outside of evictions, because I think the second question that I get the most common is, actually my tenant vacated and they left me with a $20,000 bill, and I don't know what to do with this bill. Can I report it on their credit score? Can I sue them? Can I do anything to hold them accountable for this bill? Well, that will depend on whether or not you have a reasonable repayment plan that tenant agreed to. So if that tenant agreed to a reasonable repayment plan and then does not pay, does not perform, so long as you didn't evict that tenant, like, and actually get a writ, the landlord mitigation program funds may be available to you. So if the tenant left voluntarily, there was no eviction, they left you with the bill, they agreed to pay and they didn't pay, there is a way for you to try to access those funds. It's not a guarantee, but that's one option.
And that expires at some point?
I don't know when the mitigation programs will expire. I think the idea is that some of the different funding sources that go into that might expire, but I don't know when the Department of Commerce's actual programs themselves expire. Because you have to think of they probably have money from different sources coming in and funding them. But once again, you do have to remember about the $15,000 maximum that you have to be concerned about. If you did evict the tenant, so let's say the tenant was smoking in the property, lit something in fire, and actually burned half the house down, but then still refused to leave. If you evicted them for any reason, those funds are no longer available to you. Right.
But you can pursue judgment.
We will talk about that. Okay. So hypothetically, it depends if you have a reasonable repayment plan or if you evicted them. If you didn't have a reasonable repayment plan with them or they refused to engage in that conversation, basically any debts between February 29th of 2020 and July 31st, landlords are prohibited from treating any unpaid rent or other charges related to a dwelling as an enforceable debt or obligation that is owing or collectible, where such payment was in whole or in part a result of the COVID-19 crisis, until such time as the landlord and tenant have been provided with an opportunity to resolve non-payment through a rental assistance program and an eviction resolution pilot program, which makes no sense, to be honest with you, because they're basically saying you cannot enforce this debt if it occurred between these dates, February 29th, 2020 and July 31st, unless you've been provided an opportunity to go through an eviction resolution program. But this person doesn't live there anymore. So you can't, I don't understand what that conversation is even supposed to look like And so like, this is one of the problems of being an attorney, you're like, how does that function, right? Who do you go with questions? There's nobody answering these questions. And then they further say, this prohibition includes attempts to collect, threats to collect, whether that's independently or through a collection agency, any filing of an unlawful detainer or judicial action, by withholding any portion of a security deposit, by reporting to credit bureaus, or by any other means, whatever that other means
Whatever
is.
that is.
Right, so when you say, can we sue them, according to this portion, I would say it's risky, because if you violate the governor's order, the AG's office is coming for you. Yep. So, my advice at this point, generally speaking, is if you have a debt between these dates, the person has moved out, you know, you are required, no matter what you do at some point, to offer them a reasonable repayment plan and to follow the statute. So that's the one tool in your toolbox that you have that you need to do, because whether it's collecting the debt later, whether it's a lawsuit, whether it's an eviction resolution pilot program, that is always step one. So knock it out. And if, you know, the problem that people have had during this process is, if you started offering those payment plans back in April and they accepted, but then stopped paying rent after April, you then technically, to follow the statute, had to offer another repayment plan and another repayment plan.
Every time they make a payment.
Right, and so then you have multiple repayment plans that you're tracking for the same tenant. So, you know, it's sort of benefited some landlords to just wait. And now that we're, you know, hopefully towards the end of these things, you know, starting to send them out and making sure they're crossing checking that box. The benefit there is that when these proclamations are lifted and you are allowed to use the court system, every communication that you had with the tenant throughout this entire process is going to be something that you can use as evidence in when you go to mediation or when you go to court. So if you offered plan after plan after plan after plan, that's something you're going to be able to use. If you did nothing, never communicated, and just sat on your thumbs, I mean, the assumption there is going to be like, well, you didn't really need the money, right? So, you know, getting those plans out is what you do. Supposedly, there's also protections that are similar to this in terms of enforceable debts in the state law that has been codified in 5918. But those are supposed to expire December 31st of 2021. So an example of that, which don't quote me because, you know, memorizing all these things is difficult, but just understanding there's these hurdles, is you cannot report to a potential landlord for your tenant if they were ever behind on rent. So during these protected time periods. So if I'm a landlord, I have a tenant that hasn't paid me since March of 2020. And I'm like, thank God they're planning on moving, right? I'm like, yay. And that potential new landlord calls you up and is like, you know, you're the landlord, this person's, you know, submitted an application. Can you verify that they are up to date on their rent? You cannot say anything.
Just up to March of 2020, correct?
No, started March of
Yeah,
2020.
you can't
Right.
share anything
Right.
after March of
I actually think it might be February 20. Some of the stuff says February 29th of 2020 and some says March 1. So, you know, but that's generally it. If they had pre-pandemic debts, I don't think that those are provided any additional protections. And as a matter of fact, I did win a case recently where, you know, the tenant had actually stopped paying in October of 2019. And then they actually had an eviction process and it was fully done by the beginning of February. It was like mid-February of 2020. So still before the pandemic, before any of the orders came down. And by the time the sheriff got the writs and the sheriff actually needed to execute the writs, it was literally the day after the writs were posted at the property that the orders came down, no evictions whatsoever. Like everything was put on a standstill.
Yeah.
And the writs expired. And the sheriff basically returned them and said, I can't operate on this. And the governor's office has told us to stop. That person had been in the property with having a writ of restitution issued against them and no permission to be on the property since March of 2020. That case was last week.
Oh, wow.
Not a single dollar offered that entire time.
Yeah, this hearing I was telling you about, what we had yesterday, same thing, they had stopped paying October of 2019. And February 18th, 2020 was his hearing date,
Right.
and, you know, it was just tossed at that.
Oh, that's early. Yeah. Anyways, yeah. And in this case, I happened to win it because, you know, this person did, you know, get an attorney. That attorney did contact me and, you know, tried to say like, well, this is non-payment of rent. You can't do this. Yeah. I was like, show me where you can't evict somebody who's already technically been evicted prior to any of the pandemic debts. Like, I'll wait.
Yeah.
And then I got a stipulation real fast. So, I mean, the thing is that like, that was a good, it's a weird thing to think like, oh, that was a reasonable win. And mainly like, you know, I'm divided in myself personally, and this is sharing a little bit, but, you know, I don't like processing evictions, right? But if you've lived in the property for free for 2 years and you haven't done anything to help yourself, there's no amount of time that could be given to you. There isn't any. There's like, what is it, 5? Where do we cut it off? Is it 5 years? Right? And so part of me is just like, well, we have to stop the bleeding stuff. Okay, so moving forward, future rent. So the current moratorium says that if there's rent that is due and payable between August 1st of 2021 and October 31st of 2021, so this month, for rent accruing during that time period, landlords are prohibited from serving or enforcing any notice requiring a tenant to vacate any dwelling if the tenant has made full payment of rent or made partial payment of rent based on their individual economic circumstances as negotiated with the landlord, or has a pending application for rental assistance that has not been fully processed, or resides in a jurisdiction in which the rental assistance program is anticipating receipt of additional rental assistance resources, but has not yet started their program for the rental assistance program, is not yet accepting applications for assistance. Don't you, God, aren't you so jealous of me being a lawyer? Aren't you so jealous? This, to me, is laughable, again. I mean, because essentially what they're saying is that if the tenant's made any full payment of rent, you now can't pursue any action moving forward whatsoever that requires them to vacate. Now notice it says landlords are prohibited from serving or enforcing any notice requiring a tenant to vacate any dwelling. It doesn't even say for non-payment of rent. So hypothetically speaking, if you do a 10-day notice to comply or vacate, you know, and it happened between August 1st of 2021 and now, I would argue if I was an attorney on the other side, I'd be like, can't do it. I'm just point at it, saying, can't do it. If they've made a full payment of rent, any notice whatsoever.
Wow.
And, you know, these are the issues that, you know, from a legal perspective we're dealing with, which is these things are not drafted carefully. Right? They are not bounced back and forth between our legislative individuals. Like that's how our bills become laws, as they're carefully crafted. They are debated. They are, you know, line itemed by multiple perspectives and multiple experiences, right? This is not that. So, but this is the law. And so, you know, and they get an attorney, if they're indigent, which the level of indigency we'll talk about later. They're indigent, they get an attorney, and that attorney's job is to look at this, look at ambiguous areas and point to them and make sure my job I'm paid well.
Yeah.
Because that's like, you know, oh, I'll go back and forth with you all day. That's what I have to do. Yeah, and the other issues I see with these things and we deal with on a daily basis is if they've made a partial payment of rent based on their individual economic circumstances, it's like, how would you even know that? I mean, the landlord's supposed to negotiate it, but if they're not negotiating and they just pay to, I mean, and if you think about it, you guys are property management companies, right? You have a portal, right? They could just log in and make a partial payment, and there's no way for you to reject it, right?
No, most
You have a
software,
system that does that?
most softwares allow you to require payment in full.
Okay, that's good to know. I deal with a lot of mom and pop landlords who haven't figured that out yet, right?
Yeah, yeah.
Right, so they're like, do I take the $50? And I'm like, I don't know. Let me think about it, let me go back to this, let me pair through it. And it's funny, because it's kind of interesting, because they're like, well, what's the answer? And I'm like, I'm gonna need to read things for a little while, and they're like, a little more money, and I'm like, yeah, but you have to understand, like, I'm reading like 6 different levels of the law that change almost daily, like, I gotta have them. So anyways, let's see here. The other issue is issue 3 here is if they have a pending application for rental assistance that's not been fully processed. So one of the cases I was involved in recently, the opposing counsel put in as a part of the declaration an objection to my action, a screenshot of an application process form, didn't put in, you know, no real information other than the tenant's name, the title of the rental assistance program from clearly like some sort of website, and just the status of processing and the date that it was submitted. That application had been submitted in July of 2020, and it was still processing. Over a year and 3 months later. So technically, if they've done that, that's it, right? So kind of laughable, and it doesn't matter like what program they're talking about. It doesn't say like it has to be a rental assistance program that is like federally funded or state funded. It could be a rental assistance program through their church where there's no timeline that requires them to comply or act on it. So once again, I bet you thought there was some good news tonight.
Do you have any?
I drove
good
an
news,
hour
Karen?
down here to give you terrible news.
Do you have any good news, Caitlin?
Yeah, I do. I hope I do.
Can we end it on a good note?
Well-
Let's get some good stuff.
Oh, you think we're at the end?
Oh,
You're like, you've been talking about
so
stopping
much.
bleeding. Can you stop my bleeding?
Yeah,
Stop talking?
my ears hurt.
So much.
Okay, so, you know, moving on, that's the process that's in place right now. The good news is that this is supposed to expire October 31st, and then the state law should step in. If it gets extended, you know, just hunker down and send out your reasonable repayment plans and document. That's what you can do. Also, there's other things where like, if you can go to your county and find programs that your tenant can apply for and send them, hey, I think you might qualify for this program, and you continue to send them documented communications, encouraging them to participate. At some point, when you do get access to the courts, this stuff will be available, and I mean, judges are hopefully reasonable, rational individuals. They will see the writing on the wall of just bad faith behavior. But once again, if you sit back and you're not doing anything and you're just sitting on your thumbs, judges will read into that as well.
That's good.
Right.
That's good news.
Yeah, like take some steps.
Right.
So as I stated earlier, so that's where we're at from a state law perspective. The other pieces that we should just touch on, just in case people didn't hear about this, but the CDC eviction moratorium that was, you know, nationwide, I think most people probably are this, but it was overturned by SCOTUS, which that was great news. I knew that it was gonna be overturned because I took one, you know, contracts 101 in law school, or sorry, not contracts, I'm sorry, constitutional rights, right? Like this was clearly an overreach in my opinion, that it was just a matter of time before they overturned it. But that was finally done. And I don't know if you guys want to end on a high note, I don't know how high note that is, but reading the opinion on that from Justice Kavanaugh who I will admit openly, I'm not a super big fan of, generally speaking, but it's a well-written opinion and it is scathing, which I really liked because the language that the CDC was leaning on to justify this action was laughable. It was like, it jaded me personally a little bit about like passing any laws whatsoever because they can be taken out of context and blatantly and patently abused for political gain. And I'm like, now I don't want to pass anything, you know, because I'm like, how far are they gonna stretch this? Right? Right. And then the CARES Act provisions that did have landlord tenant protections in it that required that if your property is subject to the CARES Act, you also had these additional federal moratoriums to deal with, right? Most of those expired, so that was good news. The only problem there is that there were some provisions that they did not specifically stated sunsetted with these with other protections. So technically, there's arguments that you have to give a 30-day notice to terminate if your property is subject to the CARES Act under any circumstances. So if your property is subject to that, you have a federally backed loan, yada, 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 you can't serve a 3-day notice to quit for waste, nuisance, and criminal activity. You have to serve a 30-day notice, right? Like it extends, the arguments are that it extends any of these timelines from 10-day notice to comply or vacate becomes a 30-day notice to comply or vacate. Now, those arguments are coming from, you know, opposing counsel, Housing Justice Project. I don't know how much they're really leaning into them because I think even they realize the ridiculousness of that. And it's kind of one of those things where you're like, how much do we want to push this because this is why we can't have nice things? If there's somebody that needs to be removed because they are, you know, threatening other members of the community and, you know, creating havoc, you as the Housing Justice Project, do you really want to say, no, they need 30 days notice, or is that going to end up being something where the judge just goes, you know what? We're not going to do this anymore. So they're using that pretty sparingly. But it's something to at least know about. Okay. Seattle, we're not going to talk about. Sorry, I'm shuffling my papers here. Burien and Kenmore, we already talked about that they extended their eviction moratorium. I will speak a little bit to Burien. Burien's eviction moratorium is a little bit more lax than Seattle's, and that they still allow you to terminate a tenancy if you're gonna sell the property or you're gonna personally occupy it. That's pretty much it. You have 3 reasons in Burien. Sell it, personally occupy it as your primary residence, or the person is a significant and immediate health and safety risk to others or themselves and the property, right? Those are the 3 basic reasons. In Seattle, the only reason you can evict anybody is if they are a significant and immediate risk to the health and safety of others in the property, and that definition is like the issue has to be continuing and ongoing.
So not even if they're selling or they're taking back.
What? No, you cannot terminate a tenancy in the city of Seattle for sale or personal occupancy. Yeah. Okay, so the Tacoma updates though, since we're in Tacoma. I wish I had a lot for you, but there were some changes that went into effect October 1st, though there seems to be some confusion about how far these changes go, because I will admit that even me sitting in on the informational meeting with the team at Tacoma, it seemed like they were a little confused about what they passed too. So we're working on that. But what they mainly did was they codified the bill 1236 into their local landlord tenant ordinances. 1236 is the statewide bill that passed in April, where we have statewide just cause. So if you're familiar with what just cause means, hopefully you are, because it's what Seattle's been doing for years, but it basically means you cannot terminate any month-to-month tenancies, and you can't even let certain term tenancies expire unless you have specific causes predetermined by the legislature and provide all the notices and the timelines that they require. Example of that would be, if you have a month-to-month tenant, you have to give 90 days notice if you're gonna sell the property. That's required under state law now. That's it. If you have a term tenancy with somebody for a year and it's their initial lease term, you cannot let that expire or require them to move out when that term expires, unless you give them 60 days advance notice before the expiration of the term that you're not going to renew it, right? So you have 16 different things that or reasons that a tenancy would terminate, and you have to fall into one of those categories. So by codifying that into Tacoma's, local ordinances, it gives them enforcement abilities that they wouldn't have otherwise. So increased penalties if for non-compliance, for example. So an example of that is if you violate any of these rules and it harms the tenant, they can charge you. I think their presentation said they're doing $500 a day for the first 10 days of your violation, and then $1,000 a day for thereafter until it's resolved. So if you violate somebody's rights, you send them a notice to terminate, 20-day notice to terminate that you're not justified in sending, and you get a notice from the city saying you can't serve this notice, rescind it. Well, every day that you don't do exactly what they tell you to do, that fee is adding up. They have the right to do that. Wow. Yeah, okay, so the other thing that you have to, or they passed some other things in there, which is in the just cause ordinances statewide, if you're the owner of the home and you're sharing, that you're renting out a bedroom in the house or a part of your single family home, and it's month to month, obviously, you can give a 20-day notice to terminate. It's back to the original law. And I think that the idea there was like, it's a totally different conversation if you have to live with the person and you're the homeowner, right? But Tacoma said, that's cute. But they said if you have 4 or more rooms that you're renting, or 4 or more separate tenants that you're sharing your home with, you no longer can use the 20-day notice to terminate. Which is interesting to me because the more different people you have living in these single family homes, the more likely it is that issues are gonna pop up that are behavioral, that are, people just don't get along and it's not working out well and you're the owner and it's stressing you out.
Yeah.
So I actually think that if they go back on anything, I wish they'd go back on that, because that's gonna cause people to live together in single family residences in very contentious relationships without an ability to cut somebody out of that. You know how that is. Sometimes you gotta cut out the cancer, right? But you can't do that. And now you're gonna end up in situations where you have domestic violence being basically bred into these facilities or these houses. And I don't think that obviously was not their intention, but the thing about legislation is there's all sorts of legislation is well intentioned, but it's like punching underwater,
Yeah.
Right. So there was a discussion in Tacoma with the business license issue, which I still have to hash out with them because it wasn't really clear what they were trying to say. But essentially what it sounded like to me was they're now requiring that 2 business licenses be acquired for every rental property in the city of Tacoma. So if you have a separate owner, so if the owner of the property it's a rental property, let's say it's a single family, I will admit I am a landlord in the city of Tacoma. I have a rental house here and I have a tenant in it, but crazy enough, even though I'm an attorney, I hired a property manager. I was like, I can't be doing this on my spare time. So technically I have to have a business license and my property manager has to have a business license
For that one property.
for that property. That's what they were saying, but I have to go back because I was like, that doesn't make sense, because I don't know if the person presenting was confused, which it seemed like she might be. Because I was thinking that's double dipping. That's 2 business licenses, 2 business license fees for the same business, right? So anyways, it's just something I want our listeners, all 5 of us, to sort of like put a pin in that, have it on your radar, think about it.
Yeah, we've looked into that and I haven't seen that. I haven't seen a property manager business license in the state in any of the cities.
Right.
Well,
This is why it
sorry,
was
there's,
confusing to me too. I was like, I don't know if this person is confused.
there's a few cities, Bremerton.
Right.
Auburn. And Lacey, I think we have business licenses,
Right.
but that's to operate as a business in their city,
Right,
as opposed to
right, the property.
the individual properties. that we
Right, so we'll see, that, just put a pin in it, keep your eye open for it, they may like release, and I'll send it to you if I get it, like some sort of statement, of like, we were a little bit confused, here's actually what the rule is. And I couldn't see the language in the code, I couldn't find it, I looked for it. But I went to this meeting, this person is supposedly the leader, I took my notes, I wrote them down, and I'm here. So the other thing that is an issue, so in Tacoma, there's a couple proposals that are coming up that people in Tacoma should probably know about. They're gonna introduce a late fee cap, so a cap on what you can charge for late fees, full stop. I don't know what that cap is going to be, but if I had a bet, it'd be like $75 is your cap on late fees. They're probably gonna do a monthly cap and a overall cap.
This is for like future.
Yeah, because you can't do late fees right now,
Right,
full stop
right,
anyway.
okay, yeah.
But the thing about all the legislation that has come down in the last year is that it's kind of a joke, because they'll pass legislation because they want to solve a problem, but the legislation's irrelevant because the proclamations have been in place.
Yeah.
So then they pass more legislation because they say they haven't solved the problem, but you haven't even let the legislation that was passed before actually work or not work.
Just spinning.
They're just legislating to legislate, and I think that, for a lot of people, that's how they make their job every day. They
That's
show
what
up
we
and
need to do, I guess.
and it's easy to pass these things because the political will is there. So it's like, hey, let's just grind these out every day. We're gonna think, how else can we make things more complicated? And then the other thing that's gonna be proposed, or is being proposed, is an increased notice of proposed sale requirements. So Tacoma doesn't like the 90 days. I think they're gonna extend it to 120 or 180 days for terminating a tenancy for sale. Yep, and I think that's coming soon. Yeah, so that's all my notes.
That's all your good news.
All my good news. It's all good news.
The good news is it's not now, it's coming down, right?
I mean, to be honest with you, I mean, I'm upset about this because once again, I'm a landlord too. Like, this stuff upsets me.
Yeah.
I hate that I can't help my clients more, but I always try to look at the bright side, and it's like, I have job security. Sorry.
Well, you can't evict, so you don't have that much security.
Oh, no, I mean, no.
Clients can't hire you.
Oh, I mean, you can. I mean, I've processed, well, this is the irony of all of this. My eviction cases are higher now than they ever were
Really?
prior to the pandemic. Because people are dumping their properties.
Yeah.
And this is not something that is going to be talked about politically, because it's bad for the political wins, but you won't hear this, and they won't do studies on it. And if they do studies, they're all skewed, because I've seen them where it's like, oh, well, we haven't seen an uptick in sale in Seattle. It's like, well, maybe because you can't terminate a tenancy
Yeah.
to sell the property in Seattle. So maybe let's wait until the moratorium is lifted,
Yeah.
and then we'll see what happens. Or, the fact that you can't terminate for sale if you've got a term lease going on.
Yeah.
So obviously, this is something that you need to look at, not in a moment, but from the beginning of 2020 to the end of 2022 or 2023, and tell me, did you just see a real big uptick towards the end there of sales? And I will tell you, as a professional, that's how so many of my cases went forward this year, more than eviction cases ever were prior to the pandemic. Because evicting a tenant for non-payment of rent is not a good thing.
Yeah.
Landlords avoid it. It's expensive, it's time consuming. They have to pay their attorney. They never collect that money. So they have always had a reason to work with tenant, right? Or to find ways to avoid eviction.
Right.
If you're selling the property, there is no motivation for you to work with the tenant if the tenant won't leave.
Yeah. That's
Right?
true. Yeah.
So that's what's, I think, deceiving here, is you'll hear, the news like, oh, we need to stop evictions, yada, yada, yada. It's like, I understand that, but like, they're still going forward because you need to sell your property, because you can't continue to bleed.
Right.
And I think that some states have actually done it right, in the sense that I can't believe I'm saying this, and maybe an attorney from California will call me and yell at me for saying this. But they did it right, where the state basically said, landlords, come to us, we will pay you directly.
Yeah. that's
Right?
nice.
If your tenant's not paying you, and just come, and we're not letting you move forward in enforcing your property rights or stop the bleeding, come to us, we will pay you.
That's
Washington is the only state that I'm aware of that basically said like, no, you can't really apply for these things or force this case forward in any way, shape, or form. You do not have to show any connectivity between COVID-19, or the tenant doesn't have to show any connectivity between COVID-19 or the pandemic and their reason for not paying. And so the Washington, in my opinion, based on what I know, is the very, very most protective. And what I think people don't necessarily realize is that is being abused, not just by tenants who, decided to quit their jobs and not, not work at all. And that's pretty, to be honest, it's probably pretty rare, but that does happen, and they are protected. But really where the abuse is coming from is like marriages that are falling apart, where this is a family law issue, right? Where they split up, one of them leaves, refuses to pay
Sure.
rent for the other one, like they're supposed to split these expenses and share, but instead, basically neither of them do anything. And they take their family court issues and they put them on the backs of their landlords. That's been a huge problem. At least I have a lot of cases like that where it's like, why would the spouse A hire an attorney to go to court to enforce spouse B to pay for spouse A's rent when, there's no punishment
Not for the not.
for her not to do that. It's like, so I'm gonna pay thousands of dollars out of my pocket to pay an attorney to deal with my family law issues, or I could do nothing and nothing happens to me. Or I could do nothing and apply for rental assistance and have taxpayer dollars pay for my family law issues. I can tell you, I probably had 30 or 40 of those situations pop up. So it's like, really, thank you, that's where my taxpayer dollars are going. It's like people's domestic issues that should be resolved in family law court, but why would they? They can just access these funds, and they do not require you to really prove COVID-19. Or they don't really require you to prove that it's just economic COVID-19. For example, you could say, COVID-19 ruined my marriage. COVID-19.
Oh my God.
Right? That's an impact. I would argue that. If I was that attorney, I'd argue that.
Good. I appreciate that, yeah.
Okay, I talked way too long. I kind of worked.
No, you did great. Thank you so much, Caitlin.
Very informative.
Yeah.
Too much, I'm sure.
No.
Is there any questions from our Zoom people?
We have not received any questions. They asked what your contact info was. So we gave your website.
I thought you were gonna say, they asked why she's breathing so
Why
hard.
are you breathing so hard?
I'm 33 weeks pregnant, so, and the baby's like right underneath my lungs, and so literally like I'm on the phone all day and I just.
Heavy breathing, that's okay.
Yeah.
No, they loved it. They said you did great. So, thank you for coming down.
Yeah.
And, we look to
Do you guys have any questions?
So many, but yeah.
Not for tonight, just wanna go home and rest and
It's
maybe
just
email me
one, like,
later?
so I just started the new position, and so this stuff is very pertinent to what I need to know. So, and I
Right.
don't know it yet, but I'm learning it.
What is your
So it's
position?
gonna be the team lead, which deals with all of the, everything. I
Just
don't
deals
know.
with
And
everything.
all of it, yeah, I was the leasing agent, finding people to put into the homes, and now, so it's.
Screening
Yes, so
process.
now, it's on the other side of the payments and.
Enforcement.
Yes. the
Oh,
enforcement,
fun.
Yes.
Oh, you're gonna regret
So,
that.
working with the owners- Oh, working with the owners and the tenants.
hopefully for just a short period, right?
For 2 more weeks, right? Yeah.
2 more weeks, it's gonna be rough.
2 more weeks, that's it.
Are all your properties in Tacoma?
No.
No? You gotta,
South King, Pierce County, Thurston County.
okay.
Yeah.
a little bit
Any
of
in
South-
Seattle?
South King.
We have a couple buried.
Yeah, just a few here.
Yeah.
Yeah, and that's the one that I'd be keeping my eye on.
Yeah.
Burien is, and I live in Norfolk Park, so I'm,
Oh, yeah.
I'm in basically Burien every day, and
Okay.
Burien's my community as well. That city council is getting more and more stacked with, the ideas and ideals of Seattle is doing it right. So,
Wonderful.
more housing laws, I'm sure, are coming in Burien, and they will probably just start mirroring more and more what Seattle looks like. So
How do you keep up with all?
I was up at 3:45 a.m.
Oh my
this
gosh.
morning working, and I've been working ever since. That's how I keep up. I mean, I'm telling you, no joke, not to complain, because I think an attorney complaining about their life is just ew. It hit many attorneys that practice this area do not touch it with a 9-foot
Really?
pole anymore.
That's what he said. It was-
Yeah, it's been an absolute, I've had to learn, relearn, research, I mean, every single day for the last 2 years. I will tell you, I was sort of laughing at the idea that I have to report my CLEs, like continuing legal education this year. And I'm talking to the Washington State Bar Association because they actually want me to teach a CLE class to other attorneys about landlord tenant law, so I'm going to, and some of these updates. But they're like, you need to report your credits. I'm like, all I have done
Yeah.
in the past 2 years is continue my legal education,
Yeah.
like every single day. I only get credit for coming to class and signing up and turning on your Zoom or whatever that is, but actually having to learn and relearn and learn and relearn changing laws in real life, I'm getting credit for that.
Yeah.
But yeah, it's been a hot mess.
A participant did say they're looking for a good landlord tenant law therapist. So if you know,
Therapist.
and I feel like being in property management, we need that as well.
First
So-
of all, if they find one, please let me know.
Right. Well, therapists, I mean, to spin the whole topic over to therapists, like they have suffered greatly from the
Yeah.
Yeah.
pandemic as well because of the just depression.
Mental health
and
issues,
health
right?
That everyone's been going through. So.
Yeah, but that one's been rough. Well, I mean, I guess maybe I'd be like, well, that just means your business uptakes, right? Like you're not learning and relearning legislation every single day and trying to, therapize. I don't know if that's a word, but that, I
It
guess.
is not.
Yeah,
Yeah.
I think that's been the biggest struggle is like trying to learn real time,
Yeah.
but also, provide value for your clients and keep your clients, right? And that's like, I've had to just simply say to people like, I don't know,
Yeah.
but I will spend the next week looking
Find
into
out.
it and I will get back to you. And, that's kind of like the problem is like, unfortunately for poor landlords is like, well, you're now beholden to, my attorney has to actually learn this and charge time for it, right? Every single time. If you don't get any credit for the last proclamation, you gotta look at the new
Wow.
proclamation. Yeah.
What a nightmare.
So anyways, unless there's any more questions, I'm gonna go home.
Yeah.
Appreciate it.
Thank you,
so
Caitlin.
much.
Thank you those on Zoom. We appreciate you. And we're looking to do this quarterly. So we'll bounce around the different landlord tenant law, landlord, I guess, issues,
Sure.
accounting, legal, and all sorts of things. So.
Well,
thanks
I will
again.
be on leave until April pretty
Yeah.
soon. So if you have the next one in April, that'd be a good time for me to like jump back in.
All right.
I'm actually afraid to leave because I'm like, if I fall too far behind, I might never ever catch up.
Yeah, exactly.
Well, hopefully, right, by January, 31st now, the reason to back home.
Right.
Right.
Thanks again,
Then you just have
everyone.
to relearn what you learned at the very